for those that aren't able to join. And also it will be stored on the website, so people that are registered for access to the members section of the FOIL website will be able to access the video in a few days' time. Just a quick request on that. If you are a member of FOIL, you can go to the FOIL website and register for access to the members section. That's where all the good stuff is stored on the FOIL website. You can also get yourself on our mailing list through that same process for any future events. Please encourage colleagues at law firms to do that. If you're from an insurance company, you are still welcome to register, but the process is to use FOIL Select. If you go onto the website, it is hopefully fairly obvious how you do that, and has the same effect, gives you access to stuff that's in the member section, but critically it puts you on the invitation list for new events as they come up. So Piers is going to talk to us this evening on costs, tenders, Calderbanks and other detritus, which is his phrase. I'm going to be talking for about 40 minutes, I think. And he says that he would be more than happy to take questions at the end of the event. So I'm sure it's going to be a cracking half hour, 40 minutes or so. So thank you very much. And I'm now going to pass over to Piers.
Good afternoon, everybody. Can you hear me okay? Lawrence, you can hear me? Okay. Yep. I think if Lawrence can hear me, I take it everybody else can hear me also. I'd like to take credit at the outset for the title to this discussion of costs and related detritus, but unfortunately I can't. As some of you probably know, it is in fact a description used by Mr. Justice Donald O'Donnell in the Supreme Court in a decision where he referred to it in those disparaging terms, because obviously cost is something that's very close to all our hearts. But I'd like to, I suppose, in this discussion this afternoon, just give you a brief update on recent events in relation to costs in this jurisdiction. So I suppose at the outset, I just want to go through what I'm calling multiple choices on the menu for defendants. So there's PIAB awards, tenders, Section 17 offers, cost differential letters, and then in particular Section 169 of the 2015 Act. And throughout this discussion, I'll be referring to various acts, and those are the acts I'll be referring to in generally. And in chronological sequence, you've got the PIAB Act of 2003, you've got the Civil Liability in Courts Act, or the CLA, I'm calling it, 2004. You then have the Legal Services Act of 2015, and then you've got more recent rules of the Superior Courts in relation to costs that have also been introduced. So I suppose that the format of the discussion we'll be dealing with today is firstly dealing with a very brief introduction to the discussion. I'm then going to be dealing with Section 8 of the CLA, which deals only with personal injuries actions. I'm then going to be dealing with Injuries Board awards, which by definition, again, are only in relation to personal injuries. I'll be dealing very briefly with O'Byrne letters, which apply to all civil proceedings. We'll then be going on to Section 17 letters under the CLA, which again applies only to personal injuries actions. And I'll then be dealing with the Legal Services Act of 2015, which of course applies to every cause of action and every type of litigation. We're then going to touch on the subject of tenders and lodgements, both in relation to the MIBI offers discretion of the court when it comes to tenders and lodgements, interest in lodgements, lodgements after negotiations and lodgements after mediations. We're then just going to deal with some miscellaneous issues in relation to costs, as you can see there that I've identified against non-party funders of litigation, and then what happens on costs on appeal. And as you know, you could appeal a substantive appeal where you're appealing every aspect or some aspects of the merits of a decision, but occasionally you can appeal solely from cost orders, and there's some authority as to how the court would receive that type of an appeal. I want to deal very briefly with cost differential orders, VAT on costs, payment on account, and then interest on firstly damages and secondly costs. So dealing, I suppose, first with the introduction, and you see that there is a quote there, and that is in fact from Mr. Justice Donal O'Donnell in the case of Rini and Interlink. And you see that, and I'm going to see if I can somehow close this. I can. Where it says, a casual observer might consider that when liability is determined and damages assessed or appropriate orders made, that the work of a court is substantially concluded. The consideration of such ancillary issues is often dealt with speedily at the conclusion of a case and may appear like items of detritus in comparison to the major battle which had just been fought. However, not only are the issues themselves of some complexity, they are also undoubtedly important and deserve the same attention from the court and practitioners as matters of substance involved in the proceedings. There is now an almost bewildering array of rules, statutory provisions, and court decisions that can come into play at the conclusion of a case, all of which reflect the significant burden of costs, the need to ration the limited court resources available, and the desirability of encouraging a reasonable and responsible approach by litigants, not only in their own interests, but also in the interests of other court users. Now, it's interesting that Mr. Just O'Donnell made those comments in, I think it was 2016 or so. The comments were certainly made before the commencement of the 2015 Act, and the 2015 Act effectively was only commenced last year, late 2019. But he at that stage had referred to the bewildering array of rules and orders and whatnot, and you can take it that it's been made even more complex now as a result of the 2015 Act, which I'll be dealing with in a moment. Just to start off the discussion, I'm going to deal with Section 8 of the CLA, which was amended by Section 13 of the Central Bank National Claims Database Act of 2018. And this deals with the initiating letter. And the Section 8 initiating letter is really, I've described as being a sheep in sheep's clothing. It is really a sort of redundant and ineffectual piece of litigation, legislation. But what it does is it allows the court to make some form of a penalty in relation to costs if the plaintiff doesn't issue his initiating letter in time. And initially it was 2 months, it was then reduced to 1 month. But there are so many get out of jail provisions in Section 8 that it really is quite ineffectual. So if the plaintiff can show that he didn't issue it within the required period without reasonable cause, then the court should not make an order. A lot of the court's discretion will turn about the date of knowledge. So if the plaintiff wasn't aware, for instance, that he had suffered a significant injury, he will be excused for not issuing the letter in time. The court would only make a penal order against the plaintiff in relation to costs where the interest of justice so requires. And then even after you get over all those hurdles, the court should only deduct such costs as may be appropriate. I'm not aware, even though this legislation is 16 years old, I'm not aware of any court decision in which a plaintiff was penalised for not issuing the initiating letter in time. There are some times where you could see that there's an argument to be made, but very often it wouldn't even be worth making the argument, I suspect. So moving swiftly along then to the injuries board, and section 51A3 subsection A of the 2007 PIAB Act says no award of costs nor any order providing for payment of costs may be made in favour of the claimant where the amount of the damages, if any, awarded on foot of or accepted in settlement of those proceedings does not exceed the amount of the assessment. Now that's a mandatory provision. It says no award of costs can be made. So up until recent times, everybody thought this was the same effect as a tender or a lodgement, and it really didn't make a big difference. The court has no discretion. It's a mandatory provision. No award of costs can be made. The significance of this act, however, has only come into the fore since the Rini and Interlink case, which I'll come to in a moment, which reversed, I suppose, generations of thinking, which was to the effect that the court equally had no discretion when it comes to a tender or lodgement. You either beat it or you don't, and if you don't, you're in trouble. In Rini and Interlink, the court said, well, there is actually in fact a discretion. in relation to tenders and lodgements. So this is therefore is where the Injuries Board award becomes extremely significant, because there is no discretion permitted. So if you were acting for a defendant and you believe that the Injuries Board award is sufficient, leave it be. Don't tinker with it by tendering something slightly more or something slightly less or whatever. Just leave it be and stand on it, because it is the best protection and insurance policy you'll get. So I suppose the only difficulties with the 2007 Act and an Injuries Board award is that it doesn't apply if a formal offer is made under the Civil Liability Act, which is less than the assessment, or if a tender or lodgement or facility is availed of. So as I indicated earlier, if you have a reasonably good PIAB award, don't tinker with it by making a tender or lodgement, and equally don't make a formal offer under the Civil Liability Act, either, because again it negatives the effect of the PIAB award. So moving then on to O'Byrne letters, and O'Byrne letters obviously only apply if there is more than one defendant, and the origin of it was in Section 78 of the Courts of Justice Act 1936, but now it's provided for in Section 1693 of the 2015 Act. Generally, plaintiffs, if they're in doubt, they tend to adopt the approach that they sue everybody, and they think they're perfectly safe by so doing, and they can't be hit with costs. That's not the case. It has never been the case. It's a misconception of the protections afforded by O'Byrne letters. And what the law has always been is that there must be some reasonable basis for suing the defendant who escaped liability. And that was established in the O'Byrne case itself in 1958, and was reiterated then in a 1969 decision of Clancy, and subsequently practitioners were reminded of again in O'Keefe and Russell in 1994. So you must have some reasonable basis for suing the people you are suing, and you can't just simply adopt a buckshot approach and sue everybody. The other interesting decision in relation to O'Byrne letters was White v. the Bar Council, and the full title is White v. the Bar Council and the Minister for Justice, and that case concerned a former judge who went back to practice and was refused, his application to be put on the legal aid panel for criminal law was refused, and he said that this was the fault of the Bar Council and the Minister for Justice. The Minister for Justice said, you can't get a certificate to be put on the panel unless you're a member of the law library, and the law library had a rule saying you can't be a member of the law library if you were a former judge. So he instituted proceedings against both of them, and he succeeded against the minister, but failed against the Bar Council, and the Bar Council sought their costs against the plaintiff sought an order over against the minister, and the Court of Appeal said that it was an inappropriate use of O'Byrne letters, because what he was looking for the Bar Council, he couldn't have got from the minister, and what he was looking from the minister, he couldn't have got from the Bar Council. There were separate causes of action, not arising out of the same circumstances, and therefore the 1936 Act, which was the relevant provision at the time, did not apply. So that was very much a Pyrrhic victory in that case for the plaintiff, having succeeded against one defendant but failed against the other. He then had to pay the costs of the defendant whom he failed against. Turning then to Section 17 of the CLA, which are formal offers. Again, it's a fairly ineffectual provision. As the participants here will probably know, the Civil Liability Act says that each party should make formal offers in relation to what, as far as the plaintiff is saying, what he will take, and as far as what the defendant says they will pay. And the courts, when considering the making of an order as the payment of costs at the conclusion of the trial, shall, which is a mandatory provision, have regard to the terms of a formal offer and the reasonableness of the conduct of the parties in making their formal offer. This is, as the section makes clear, an entirely separate and distinct procedure available to the parties over and above and separate to, say, lodgements, tenders, and matters such as that. Now, in on paper, it seems like a fairly useful provision, but in practice, I'm sure, as everyone here knows, it is honoured more in the breach than in the observance. Very rarely, in my experience, do plaintiffs make formal offers. Even more rarely do defendants make formal offers. And very often I find that defendants don't even bother asking the plaintiff to make their formal offers, because I think they realize that nobody actually complies with this legislation in any event, even if requested to do so. So you can see there from the Act which I've quoted, the court shall have regard to the terms of the offer and the reasonableness of the conduct of the parties in making the formal offers, but the court isn't permitted to have regard to the fact that the plaintiff has not made an offer. So it's fairly ineffectual. As I say, it does not add anything to the existing suite of options available to parties, particularly defendants, as to what they can do when it comes to trying to protect their client. The rules provided must be made by each party within 14 days after service of the notice of trial, but in practice, I suspect neither plaintiff nor defendant are ready at that stage to make a formal offer. Certainly, it's prior to disclosure under SI 391 of 1998, so it's very hard to actually assess what the cases are worth at that point in time in the process of the litigation. The court can order a party to comply, and there's a decision of the President there, Mr. Justice Kearns, in that regard. But the case in question identifies one of the significant lacunas in the legislation, which is that it does not say who must make the first move. And there is no express penalty for non-compliance, except by simply bringing a motion trying to force the other side to make their offer. But then the consequence of that is that you too have to make your offer. So if you were to bring a motion against a plaintiff to make an offer, then the plaintiff would just reply by serving an equally hostile motion on the defendant asking for your offer. So it's not necessarily a useful piece of legislation. So I'm now turning to the 2015 Act and the 2019 statutory instrument which relates to that Act. And they're the relevant commencement dates. As you can see, sections 168 and 169 commenced on the 7th of October of last year, and the SI commenced on the 3rd of December. There's a number of decisions as to whether or not those provisions are retrospective, but I don't believe in the time available we'd have time to go through those provisions. They're not entirely clear because all of those decisions effectively did not decide whether it was retrospective or not, but decided they were going to apply the old law in any event, and have said that they come up with the same result if they had to apply the new law. So it's not particularly helpful or clear as to what is the position. In relation to section 168 itself, then it just is entitled the power to award costs, and it says that the court can at any stage from time to time, or obviously at the conclusion of the proceedings, order that a party pay the costs of the proceedings. And a subsection 2 says the order may include an order that a party shall pay a portion of another party's costs, or costs from or until a specified date, including a date before the proceedings were commenced, which is obviously an interesting provision. It can direct that the costs relating to one or more particular steps in the proceedings could be covered. So equally, it could, for instance, say you get your cost of the proceedings, but you won't get the cost of the discovery, for instance. And there was a decision of Doyle v. O'Donovan recently where Mr. Justice Simons specifically disallowed the plaintiff's costs of making discovery, because even though they swore an affidavit of discovery and that was of the medical records, they simply lumped it all together as in whatever, Section A, medical records from St. Vincent's Hospital, and they didn't list out the individual records, and he felt that was an inappropriate manner of swearing an affidavit. It was contrary to the Beulah case, and therefore the plaintiff wasn't entitled to the cost of the discovery aspect. Then you see at subsection D, it says where a party is partially successful in the proceedings, a cost relating to the successful element or elements of the proceedings can be awarded. So you can see there is a whole range of options open to the court now as to what they can and cannot do with an order for costs. Section 169 then says a party who is entirely successful in civil proceedings is entitled to an award of costs against a party who is not successful in those proceedings, unless the court orders otherwise. So the default position is that if you're entirely successful, you should get your costs. Of course, the real issue is what does entirely successful mean, and that is not defined. But if the default position doesn't apply, then the court should have regard to the particular nature and circumstances of the case and the conduct of the proceedings by the parties. And then the court or the legislation goes on to say, including, and it gives a number of subparagraphs there. And I'm going to go through those now in turn. The conduct before and during the proceedings, whether it was reasonable for a party to raise, pursue, or contest one or more issues in the proceedings, the manner in which the parties conducted all or any part of their cases, whether a successful party exaggerated his or her claim, whether a party made a payment into court and the date of that payment, whether a party made an offer to settle the matter, the subject matter of the proceedings, and if so, the date, terms, and circumstances of that offer, and where the parties were invited by the court to settle the claim, whether by mediation or otherwise, and the court considers that one or more than one of the parties was or were unreasonable in refusing to engage in the settlement discussions or in mediation. So obviously there's a whole range of things there, and I'm going to go through them in some greater detail in a moment, but perhaps just to, as we're dealing there with the very last one, it is an unusual provision because this is where the parties would be invited by the court to settle the claim, whether by mediation or otherwise. Now, there's nothing unusual about the mediation provision. It's the or otherwise is interesting because it goes on to say, and the court considers that one or more than one of the parties was or were unreasonable in refusing to engage in the settlement discussions or in mediation. So obviously the first part of subparagraph G doesn't mention settlement discussions. It says or otherwise. The second part identifies settlement discussions. So you could certainly imagine if, for instance, you were acting for a defendant and the court was sympathetic to the plaintiff, but realized the plaintiff perhaps was not out of the woods and was perhaps in some difficulty, how the court might suggest to the parties they go out and maybe see if they could settle their differences. And if the defense indicated, no, judge, we want to proceed with the case and we don't want to go outside and settle, then this gives the court a specific statutory provision. This is a specific statutory provision which allows the court to take that refusal into account when considering the costs of the case. So that's a new provision, obviously, which hadn't been on the statute books before. So there's a recent decision of Chubb from the Court of Appeal, and Mr. Justice Murray categorized the new sections in the new Act as into two categories. Firstly, where someone is entirely successful, and he said in that default position, the party is entitled to an award of costs unless the court orders otherwise, and whether in determining whether to order otherwise, the court should have regard to the nature and circumstances of the case and the conduct of the proceedings by the parties. Then he says, further, the matters to which the court shall have regard in deciding whether to so order otherwise include the conduct of the parties before and during the proceedings, and whether it was reasonable for a party to raise, pursue, and contest one or more issues. And this in turn then goes back to that decision of Veolia, which I'm sure everyone attending this CPD will be familiar with. The court, or you will be familiar with the fact that in Veolia, Mr. Justice Clark said that in complex litigation, the court could make a nuanced order in relation to costs, whereby witnesses and expenditure relating to an issue upon which the plaintiff was unsuccessful may be disallowed, and the plaintiff may be ordered to pay the defendant's witnesses and expenditure on that issue. And in it, not only witnesses and expenditure, but also for additional court time for a trial unnecessarily elongated. So not only would the plaintiff not get his costs or his full costs if the trial was unnecessarily elongated, but the court was entitled, in fact, to direct the plaintiff to pay the defendant's costs for that elongated portion of the trial. So this was the background to the new Act, which was the Veolia case, which was back in the mid-2000s. And Mr. Justice Murray in Chubb, when he had considered the new Act, went back to Mr. Justice Clark's decision in Veolia, and he said, Clark J. in Veolia, at least in one view, limited his explanation of the power of the court to reduce the cost of the party who prevailed on the event by reference to the costs incurred by the other party in addressing issues on which the former did not succeed to cases that were complex. No such express limitation appears on the face of the legislation. Now, that's a monumental change in Irish law, because Veolia in itself was a monumental change, but it limited the the power of the court, as it were, to penalise a partially successful plaintiff to complex cases. It's commenced being invariably commercial cases, and then, as we can see in a moment, stretched out and expanded into less complex cases. But here now, for the first time, the legislature has intervened and said the Veolia principles apply across the board, irrespective of the complexity of the litigation. And that's very significant. So what Mr. Justice Murray then in Chubb also dealt with was the second category. So the first category is where somebody is entirely successful. So the second category is where someone is partially successful or not entirely successful, to put it another way. And he said that the court, in the exercise of its discretion, may also make an order that where a party is partially successful in the proceedings, it should recover costs relating to the successful element or element of the proceedings. And even where a party has not been entirely successful, in other words, where they've been partially successful, the court should still have regard to the matters referred to in section 169 1A to G, which were the ones I identified earlier, when deciding whether to award costs. So basically, whether you're entirely successful or partially successful, the court is entitled to have regard to those 6 factors which I've identified earlier. So the first of those factors was the conduct of the parties in the litigation. And I'm terming this litigation misconduct. And it provides that section 1691C is that the court can have regard to the manner in which the parties conducted all or part of their cases. And that's also provided for in Order 99 Rule 10.3, which says the court in awarding costs to which this rule applies may in any case in which it thinks fit to do so, order or direct that the cost should be adjudicated on a legal practitioner and client basis. Now that's obviously a new statutory provision and is, I suspect, something that could strike fear and terror into parties and more likely the solicitors and counsel on each side. There's 2 decisions there that are of important, Doyle and O'Donovan, which was the decision I briefly referred to earlier of Mr. Justice Simons. And then there's also O'Carroll and Orish Slánta, which is a Court of Appeal decision. So the Doyle v. O'Donovan one is quite interesting. It was a rear-ending road traffic accident. The defendant pleaded that the rear-ending was deliberately caused by the plaintiff. That's something I'm sure we've all come across on numerous occasions in our practices. The defence, of course, was supported by an affidavit of verification, although the defendant in the circuit court, because it started off life in the circuit court, did not advance any specific testimony to support same, and indeed disavowed any knowledge of that plea when cross-examined in the circuit court. Nevertheless, even though that plea had been made, supported by an affidavit of verification, and then effectively abandoned in the circuit court, the plaintiff's claim was dismissed. Not surprisingly, the plaintiff appealed. Shortly before the appeal, the defendant conceded liability. So as you can see, there seemed to be considerable movement, to put it mildly, in the respective parties, and I think the decision of the circuit court probably was at that stage even considered by the defendant to be very unfair. The plaintiff therefore sought aggravated damages in reliance on the decision of Conway v. the INTO and also the decision of Swain. And the court, rather than granting aggravated damages, awarded costs on a solicitor-client basis to the plaintiff, following a recent decision of Mr. Justice Barneville in the decision of Trafalgar and Mazepan, in order to reflect the manner in which the defence was conducted and the court's displeasure at the manner in which the defence was conducted. So there is, I suppose, a classic example of where the court decided that rather than awarding aggravated damages, the court instead would award solicitor and client costs. And as I've indicated there earlier, the court disallowed the cost of the discovery as the plaintiff failed to list the individual documents. The next case is O'Carroll v. Orish Slánta. In that case, Mr. Justice Cross in the High Court dismissed the plaintiff's claim primarily on the grounds that she had failed to establish the appellant has breached his duty of care towards her. However, Mr. Justice Cross felt that an allegation of fraud had been made against the plaintiff, and in his view, this allegation was without any merit, and he considered that the court should mark its disapprobation of this unfounded allegation by refusing to make any costs in favour of the defendant, even though the defendant had been successful. So the defendant appealed that to the Court of Appeal, and Ms. Justice Power held that the court was entitled to indicate his disapproval of the line of inquiry, but making no order for costs went too far. She felt it was disproportionate, and accordingly, she awarded 50% of the costs of defending the claim. We discussed earlier the case of Veolia and how it had been confined to complex litigation, Miss Justice Irvine, in a decision from 2013, said that medical negligence litigation is considered to be complex, and said Veolia principles apply there also. And the plaintiff had only been successful in establishing liability in respect of one of the occasions of which he was complaining. So there's 4 different allegations in 2 different hospitals over a period of years. The plaintiff was very, very unsuccessful in most of those allegations. And the court found that of the 21 days spent at hearing, less than 20% of the time was spent dealing with the part of the plaintiff's case which was ultimately successful. Now, the reason why I'm referring to this is that in that list of 6 subparagraphs of section 169, the court can take into account the reasonableness of the case and the not only the conduct of the case, but also the number of allegations made and as to whether or not they were sustainable. And Miss Justice Irvine, in this case, felt that there were significant issues which had been alleged, significant allegations made which hadn't been supported, and that it was very unfair because there was no penalty available at law against a plaintiff for making scattergun allegations effectively, which had little or no chance of success. So the Miss Justice Irvine, as you can see there, had very, very serious comments to make as to the lack of, as it were, protection for a defendant who facing such litigation. And what she did in that case was that she said it was appropriate for the court to engage in a detailed analysis of the case when deciding what ultimate order for cost should be made at the conclusion of the proceedings. And what she did in that case was awarded the plaintiff 65% of her costs due to her failure to establish any liability in respect to the allegations forming the basis of the first 3 legs of her claim. And she said that the effect of vastly increasing the duration and costs of the proceedings. But she was nonetheless the overall winner of the litigation, and she felt it would be unfair to reduce her costs below that level of 65%. I'm sorry for racing. I hope I'm not going too fast here, but I'm conscious of the time. I'm just going to, on that same point about whether the court can and should have regard to the reasonableness of the parties in pursuing certain aspects of the litigation. There's a decision of birth thistle by Mr. Justice Barr, which is also medical negligence. And in that case, there were 2, he said there's 2 schools of thought as to which was the appropriate course of treatment. And Mr. Justice Barr went with the defendant's school of thought effectively. And there were a number of aspects to the case. The plaintiff succeeded in some aspects but failed on the other aspects. And he said the aspects he failed upon was that there was 2 schools of thought and the court preferred the defendant's schools of thought. And the court accepted that the length of the trial was prolonged to some extent by virtue of the investigation of this aspect of the case. In other words, the bit he failed upon. But he found that there was no additional witnesses necessitated by this temporary wire issue, which was the one the plaintiff failed on, and the length of the trial was only marginally prolonged. So in that case, the plaintiff recovered 80% of her costs. Now, one of the other issues or provisions, should I say, in the legislation, in those list of 6 matters to be considered, was a party's exaggerator's claim. And as everyone is aware, under Section 26 of the 2004 Act, the defendant can make a defense or advance a plea to the effect that the plaintiff is exaggerating his or her claim under Section 26, and the court can actually dismiss the claim under those circumstances if that's successful. This provision now of the 2015 Act isn't so much dealing with dismissing the claim, it is with making an order in relation to costs where somebody has exaggerated the claim. And in Simpson v. the Government of Mountjoy, the Supreme Court in July of this year held that the plaintiff was entitled to damages of €7,000 for breach of his constitutional rights, but there was a 30-day High Court hearing. He found that there was lies and exaggeration by the plaintiff in his testimony, and he was an unreliable witness. And he said it was effectively an attack on the integrity of the court process. And there's some very harsh words there. And he says there comes a point where falsehood, dishonesty, and fabrication can be seen as an attack on the integrity of the court process, so as to constitute an abusive process in a more specialized sense of the term. The courts are entitled to protect themselves against such conduct. There will therefore be occasions where the conduct of a plaintiff in bringing a fraudulent or grossly dishonest case must bring serious consequences and costs. Such instances will be rare. The jurisdiction should be used sparingly. A litigant who comes to court prepared to lie and exaggerate to the extent which occurred in this case cannot expect to escape without significant sanction. So here we have, as opposed to, I suppose, a lesser, less draconian remedy than dismissing the entire claim, hit the plaintiff on his costs. There's another decision then in relation to damages arising out of an RTA. It's a pre-2015 Act case, Dardis and Poplova. And again, the plaintiff in that case was seen to be exaggerating his claim. He received 3% of the sum claimed for his loss of earnings. And the court felt that the plaintiff shouldn't be deprived of his costs as long as there was some medical evidence on which he was justified in advancing the claim at the trial, but that the court should take a view as to whether it was a stateable case on the issue or whether it was unstateable. And if it was unstateable, he should not recover his costs in respect of the time spent trying to establish such an unstateable claim. So again, it's again somebody who's exaggerating, who will be hit with costs as opposed to having the claim dismissed in its entirety. That was significant at the time because it extended the pre-2015 principles to an RTA which was non-complex, but as I say, that's been overtaken by events anyway in the Act. And the next provision then in the list of statutory provisions of in section 169 is a Calderbank letter. It's the first time that the Calderbank letters has been placed on a statutory footing, but in relation to a Calderbank letter, the law is clear, as set out in a decision of Miss Justice Lafoy in Murnahan, that the letter, the Calderbank letter, must be clear, cannot give rise to any confusion or uncertainty, and it must deal with every aspect of the case, including the costs. And now, as a result of the 2015 Act and Order 99, the new statutory instrument, the court must have regard to such a letter when considering costs. So that's very important because prior to this, Calderbank letters were not available, for instance, in personal injuries actions or in any type of an action where you could make a lodgement. Since the 2015 Act, they're available now in all types of litigation. So there is the relevant extract from the statutory instrument which deals with Calderbank letters under the new Order 99. You will recall then that the last subsection in the 2015 Act dealt with the question of when a court directs you to or invites you to attend mediation or settlement discussions and a party declines. I've already discussed the question of settlement discussions, which is a new provision. The provision in relation to mediation is not new at all because that was already in the 2017 Act, and I don't believe the 2015 Act, which, as I say, came into effect and commenced after the 2017 Act, actually adds anything to that provision. So then when we come to tenders and lodgements, which is the next part of the discussion, parties will probably be aware that the MIBI agreement has its own inbuilt tender procedure which allows the MIBI to make an offer of satisfaction, which is the same effect as a tender, up to 10 days before the hearing, which is obviously a great facility if you're acting for the MIBI. The rules provide then for, as it were, the rest of us, other than the MIBI, that you can make or increase a payment by way of lodgement without leave of the court, following, for instance, the delivery of replies to particulars by the plaintiff or the delivery of unsolicited particulars by the plaintiff. So you can top up your lodgement if you get particulars which change the nature of the claim. There is, as I said, in the Rini case, for the first time now it's been identified that the court has a discretion in relation to a tender and cost. So if you fail to beat the lodgement, or if a plaintiff marginally beats a lodgement, then the court has a discretion as to whether or not to award the costs against the plaintiff or in favour of the defendant. As I say, there's no such discretion if you fail to beat a PIAB award. The court indicated that the closeness of the ultimate award to the lodgement is important, and they quoted the 5% rule. If you're within 5% of the lodgement, then the court should perhaps exercise its discretion. In Rini, the plaintiff actually was 98.3% of the lodgement. The court said there was a number of variables involved as to whether or not the court should exercise its discretion, such as how the claim is comprised, whether the claim was complex, whether there were lots of moving parts, as it were, in assessing the claim, whether there was VAT, whether there was issues and dispute that ultimately required, as it were, almost like a mini trial within a trial. The court also considered the effect of interest and whether or not the interest on an award should be taken into account when considering whether or not you've beaten the lodgement. And the court said, no, you must ignore the question of interest. The award is the award excluding interest, and the only issue to consider is, was that in excess of the lodgement or below it? The sting in the tail of Rini, which is that, well, yes, if you're within 5% of of a lodgement, we can exercise our discretion. But they also said is that if a plaintiff barely beats a lodgement, then it might be unreasonable not to have taken the lodgement, and the court should be entitled in such marginal cases to withhold some or all of the costs. So that's a very important provision if you're acting for a defendant. So there I deal with that slide that there's no inhibition of making a late lodgement after settlement negotiations. And as you can see from the 3 cases there, I cite similar provision applies in advance of or after a mediation, although it would be wise in advance of the mediation to write a letter to the other side saying if the mediation is unsuccessful, we're reserving a right to make a lodgement or a tender. There's so slides there are interlocutory applications, which I'm not going to deal with, other than to say that whereas the tendency was always that the court should reserve the costs, the provisions now are the opposite. The court should deal with the costs unless it's not possible to do so. And as I say, because of the time, because we're already on 40 minutes, I don't intend dealing with that. There's also a slide dealing with the rare case where you can make an order for costs against a non-party funder of litigation. As they say, that's a rare bird indeed. There is then dealing with appeals from substantive orders made at the trial, and where damages are reduced on appeal. Mr. Justice Gagan gave the leading decision in the case of MN and SM, where he effectively said there should be no orders to cost in that case. So the defendant succeeded in getting the damages reduced, but the plaintiff still succeeded in getting an awarded damages, and the court said there should be no order. But then the case of Shannon and O'Sullivan, as it were, introduce protections for the defendant by permitting the defendant to, for instance, make a Calderbank offer in advance to the plaintiff. So the court, however, said that even if there was no Calderbank letter in that case, they would have awarded the cost to the defendant. So it was a variation slightly of the Mr. Justice Gagan decision. Appeal solely from an order for costs, very hard thing to do. The court said there has to be a substantial departure from the accepted principles guiding determinations and costs by the High Court before the Court of Appeal would intervene. So there's also cost differential orders, and the significance of same obviously is in the decision of Moyne v. Sika. And again, the court is obliged to make a differential order unless there are good reasons for not doing so. And I'm sorry now for speeding through this, but time is of the essence. And the effect of all that is that the onus on the plaintiff to ensure that the proceedings are conducted in the lowest court. The court noted that the ongoing process of a plaintiff and medical reports that are received from time to time until the case is listed for hearing will usually clarify the level of general damages that the injury sustained by the plaintiff can reasonably be expected to attract a trial. So that says there's an onus on the plaintiff's lawyers to keep a close eye on the case and see if the damages are going up or down. And if they're going down, they should be remitted back, say, to the circuit court. And in that case, the defendants had acted very prudently by issuing letters warning the plaintiff that they were going to look for a cost differential order. So the next matter, and we're coming to the end, is interest on damages on costs. The Courts Act 81 obviously allowed for interest on damages, which is a useful statutory provision, but in fact was a fairly blunt tool in the majority of cases. The 1981 Act specifically excluded the power to award interest on general damages. It said it was simple interest rather than compound interest. The court could fix the period, but not the rate. The rate was fixed by the minister. For many years, it was 8%, is now 2%. But I suppose the more interesting point in relation to it is that court says that the assessment of interest is not a precise science, and there's an element of guesswork as to whether the award of interest over or undercompensates the success of a plaintiff, or instead approximates to fair compensation. And it reiterates that the award of interest is discretionary. And if anyone is interested, sorry, no pun intended, in looking at this question of interest and awards, you should go no further than to read Mr. Justice O'Donnell's decision in the Reaney v. Interlink, because he shows how the court can award interest commencing at a certain date when it became, for instance, unreasonable for the defendant not to make an offer, or whether there was some delay in progressing the litigation, all of which can go into the mix, and the court can award interest for some periods and not for others, and it can award interest in some sums and not on other sums. So, as I say, the court says you can take into account how diligently the proceedings are being prosecuted, whether there's a genuine dispute. All of those matters can be taken into account. I should say that payment of interest on costs is now provided for in the 2015 Act, and that's probably a useful provision also for particularly defence solicitors to bear in mind, because no doubt the plaintiff solicitors will be looking for the interest on costs now that it's specifically identified and highlighted in the legislation. So we're all familiar then with payments on account under Order 99. It is not dependent on there being a delay in the taxation process or the adjudication process as it now is. But in fact, I understand that in more recent times, parties do not require an Order 99 provision because of the fact that the process has been speeded up. But as I say, it is not necessary for a plaintiff to establish there's a delay before they can seek such an order. In fact, that slide was out of sequence. That is the provision in the 2015 Act, which says that the interest and costs can now be ordered, and it says it can be ordered from a date before the judgment. So that's obviously an interesting provision. A set off for damages or costs between the parties may be allowed, notwithstanding the solicitor's lien for costs in the particular cause of matter in which the set off is sought. That's in Order 99 Rule 6. And that obviously would be important if a plaintiff fails to beat a lodgement or a tender. And then just in relation to VAT on costs, I'm sure you're all familiar with that, but the plaintiff is entitled to the VAT on costs where and only where the plaintiff establishes that such sum is not otherwise recoverable. So that concludes the CPD. Apologies for perhaps racing through it, particularly towards the end, but I'm conscious of the time. We're now up to 46 minutes. And if anyone wishes to ask any questions, I'm here to answer them. The slides are available if Lawrence wishes to distribute them. And as he's indicated earlier, this is recorded in any event for posterity, although it'll probably be out of date fairly soon. In any event, looking at the number of decisions that come out of the courts every day now in relation to costs, I'm sure if any of you are looking at the legal updates that you get through the email or through the post or whatever, there's probably a good 25% of cases now deal solely with costs. So that's it. So if anybody's any questions, perhaps Lawrence, you could direct them my way.
Yeah, thanks, Piers. That's a really, really interesting talk, and I've certainly learned a lot myself, but though I did start from quite a low point. Does anybody have any questions they'd like to ask? You can use the chat room facility, or now that the talk is over, feel free to come off mute and just ask your question directly. Seeing any sign of anybody coming off mute.
I'm getting a free run, am I?
It looks like it, yeah. No. Okay. All right. Well, look, thanks once again, Piers. It's really, really kind of you to give that talk for us. As I said at the beginning, we'll do a write-up of this based on the video recording, and the recording itself will be available on the FOIL website. We'll make a point of sending that to all lawyers who are registered for access, even if you weren't able to attend, if they weren't able to attend today, so that it will get the widest possible audience. So thank you once again, and if I don't see you again, have a happy Christmas.
Thank you very much. Thank you all. Bye-bye.
Bye. Bye.
Thank you.